Thanks, Ian. Afternoon, everybody. Thank you for joining us. My team works alongside Ian and his colleagues, and the final pull-up chart at the end, really focusing on, I guess, the equipment that the data is processed and accessed and ultimately removed from. So whether that's the acquisition of technology devices, how they're managed in life, or as importantly, how they're disposed of. So we've provided a number of bits of content over the last 12 and 18 months that you can have access to in terms of GDPR, white papers, but also some practical tips and advice. So we're vendor independent, we're not here to sell, not that there is a GDPR solution for one size fits all, but it's about practical things you may be able to do or share with your customers in terms of how we navigate this journey with regards to technology assets themselves. But happy to take any questions either now or at the end of the event, and we can get in touch via Ian's team and help you out, hopefully.
Right, we've got consent somewhere on the line to share.
Good point, yeah. You need to call me.
Yeah. Maybe you want to lead us off with the first question.
Do you need consent to market to somebody who you have an agreement with to provide your products and services to their clients? Because you're marketing your products and services to them, but they're then selling them on somebody else.
Yeah, so consent is only one basis of processing, and wherever possible you should put it under another one of your bases. So depending upon how your contract is structured, you may well be able to rely on the contractual basis that they have asked you basically for that information. So it comes down to your contracts and also your explanation of what your product, service and ongoing relationship will look like. So if it's very clear that that's part of your service delivery is the provision of that information, then that provision might not amount to marketing in the first place, so it could potentially come outside the scope of needing consent.
Yes,
how long can we keep data for an individual, for a sole trader or a partnership?
So you need to, assess what legal obligations you're under to maintain that information. So you should work out what all of your your legal statutes and requirements say. And then there's no right or wrong answer. You can pick how long you wish to keep it for. What you need to do is be transparent about that and make it very clear before, ideally, someone gives you information how long you're going to keep it for. But the reason why you need to distinguish between your policy on data retention and your legal requirements for data retention is in case you get those requests to be forgotten. Because what I'd hate you to do is delete any information that you have a lawful basis to hold for an HMRC perspective or an FSA perspective or any other rules and regulations you may be subject to. But as long as you're transparent about how long you wish to keep data for, then that should be fine. So I've got some clients who say they will keep their client files forever and they will never delete that data, and they're very transparent with their clients about that.
So that needs to be documented in our consent form, but what about the data that we will have on our system? I'm sure there's lots of other people that predates consent forms and FCA and what's gone on in the last couple of years.
Yeah, but if it's your client data, then my argument would be consent's irrelevant because that's not your basis of processing, and the fact that you've held it before the rules is it's not necessarily problematic because you will be having touch points with them on an ongoing basis, I would assume. So it's about looking at all your touch points with that customer and when it's appropriate to bring to their attention how long you're going to keep their information for. So in a law firm's example, which I appreciate is a slightly different context, but at the end of a transaction or a matter, we'll write to them and say, this is closed, here's your final invoice normally, and by the way, this is how long we're going to keep your file for, because that's an appropriate time to tell them. They possibly could have found that out on day one if they looked and through all the terms and conditions, but it's about telling people the information they need to know at the right time. So as long as you look at that life cycle journey, I'm sure you can find a situation and a time when it's appropriate to inform those clients about your retention policies. You don't have to necessarily retrospectively go back and tell everybody, not necessarily.
Well, at Close Brothers, we have to keep client documents for 7 years post-settlement, and that's because of FCA rules. So we will keep it for that time. A client can't contact us and say that they, wish to be forgotten or they want us to delete that information. And we do state that in our privacy notices. We don't request consent for that because that's not the legal ground we go under. So when a client completes one of our agreements, the information they're giving us is either because of contractual necessity or because it's a legal obligation for us to, for example, do AML checks, etc. So consent is only collected when we want to do marketing. We steer away from consent because it can be revoked. So if you don't need to use it, use another legal ground, guys. You don't want to be challenged on consent.
And you might want to look at client files and think about there might be elements of those that you need to keep for different time periods. So we have to do AML searches and things like that. That part of our client file is dealt with very differently to the emails they might send me about a contractual negotiation we're involved in. So you should think about the breakdown of the information you hold, and we've got to be proportionate. We've got to get you as ready as you can for the 25th of May, but it is worth thinking about the different types of information you hold as well.
So it's conceivable that every single broker in here could determine a different time period?
Yeah.
But they just have to be able to justify it?
Yeah. And they need to have said that in their privacy notices, and their as long as you can evidence when you've told the individuals about it, that wouldn't be a problem at all.
Sorry, Ian, didn't I have a question? What about fraudulent information? We get quite a few individuals who come to us who are identified as fraudulent cases. We're in a sort of motor finance business. But we want to keep that information on file to prevent being attacked again, if you like. That's personal information I'd hold forever, just in case they came back again. But I'm just slightly unsure about, as long as we protect it.
So
Should there be a retention period on that? Or?
If you think that you absolutely need to keep it forever, then you need a justification for that. But normally I'd say be really careful when you are setting a time period. Does it need to be kept forever, or could 5 years maybe be enough? Could 6 years be enough? So make sure that whichever time period that you pick is justifiable should the regulator ever contact you about this.
I'm very uncomfortable by my client who's decided to keep their data forever, because whilst they have, we've done a whole assessment, we've got a nice written statement as to why they've come to that decision, I think it could still be challenged. And I'm also nervous that they're just creating more and more and more and more and more data that they've got to control and manage and put the appropriate technology and security around. And, the more you have, the more issues you're potentially going to have. So I try and steer people to be as lean as possible and to delete, but that is a very difficult exercise because people by their very nature don't delete anything. We were talking earlier, I was saying I keep every email, even, someone sending me a smiley face or something like that. I've probably filed it somewhere because I think the tendency, especially for lawyers and financial sector, is to keep everything, but we need to sort of change mindset slightly.
A live system, you might keep backups for over a decade if it's particularly critical systems or financial information on the business.
Yeah, so you need to have policies about that. So what you would say in terms of your data retention policy is when you're going to you should time it so that you ideally do capture your backups as well. And I think that's more important from my perspective is when someone exercises their right to be forgotten. So what you'd normally respond is to say that you've deleted from all of these sources, but I'd probably put proviso on there, but there is a backup. But if we are in the situation where we restore that backup, we will delete you from the restoration. But it's a brilliant point to raise, and these are the sorts of nuances you need to be thinking about, and you need to try and align as far as possible deletion of backup information with the deletion of your sort of live database. But it also links into, and I'm conscious we've talked about an awful lot today, it links into where you have historical information that you might archive, looking at pseudonymization and anonymization as far as possible, but that possibly isn't relevant for true backup data. Because you don't want that to be anonymized, because then it'd be pointless as a backup, wouldn't it?
There's one more, David.
Going forward on this question of consent from our clients, do I have to contact everybody that's on my database and ask them for a fresh consent or for a consent form to be able to deal with them going forward?
So I would argue only for direct marketing and only if the consents you have today are not valid under the new GDPR requirements for consent. So a good example of that is that you can no longer use pre-ticked boxes. So it tends to be on lots of internet sign-up sheets. You had to untick the pre-ticked box for consent to marketing. So if you've used pre-ticked boxes, all of those consents will not be valid as of the 25th of May.
I've never got a consent. Never asked for one because it's never been required. So what do I do with it all?
I'd say look at the lawful grounds that you're using. So if you've collected that client's information because you've provided them with a service, then you may still need that information and it's not consent that you need to get. You can do it on contractual necessity or in some cases legitimate interest. So look at the ICO guidance on this. It will give you all the lawful grounds that you can use. And it's unlikely to be consent if you need it for contractual reasons.
Yeah.
But if you want to do direct marketing to those people for new products, you would need to get consent, presumably.
You'd need to have the correct marketing permission. So in the majority of cases, yes, it would be consent.
And could you send out a general sort of email to the various blocks of customers, or would it have to be, would you have to contact them in a different way?
There's difficulty around this because of the Honda and the Flybe fine. So what they did is they wanted to contact all their customers and say, will you give us consent to market to you? But when they did this, they'd contacted customers who'd already opted out of marketing.
So they were fine because of that.
Okay, so you've got to be careful.
You do.
Yeah.
But
The principle of you could do that.
you could do a bulk email campaign to everybody in your database requesting it, but that does come with risk.
Make sure that there's no one who doesn't want to.
He's already said don't contact me.
Yeah, and make sure you can evidence the consent or the basis on which you're sending that today. So lots of people are looking at more intuitive ways. They're looking at when, they would have a natural touch point, whether it's sort of an account meeting or an update or a refresh, and trying to get it in more subtly at a different point in time, because if you have the opportunity to meet people face to face, your likelihood of getting consent in a face to face scenario tends to be higher than just a general email from a nondescript individual.
How would you record that consent? So if we were out talking to a broker or a client and it came up in conversation as part of a review of credit facilities, is that just recorded on a CRM system, or would you want to get something signed? How would that work in practice?
So every business will be different. So for some businesses, it might be appropriate for them to take a paper form with them and get them. So we could have given out a paper form to everybody here today and asked them, but with no obligation, to fill it in. If it's a conversation with you, what would probably be more appropriate is you get back to the office, you put it in the CRM system, and then there's some sort of automated email that goes back to sort of say, or from you to say, hi, great conversation, just to let you know this is the way I have marked your preferences within our database as per our conversation.
So a file note would be evidence?
Yeah. If they complain, and if you have got to justify it, it's what's the story or the scenario or the explanation you're going to tell. And if you've got an email and a contemporaneous file note, that's going to be really great evidence. So the likelihood of them being able to pursue a claim against you would be so very minimal. But you do have to be pragmatic. If you're inviting someone to an event and they've gone to that event every single year, is it really appropriate that now we don't invite them ever again because we don't have their valid consents when they or might be personal friends of somebody? Or you do have to be really pragmatic with this and think about it as to what's going to work for your business and be suitable. But the backstop is you really do need express consent.
Okay, all right.
Slightly different. Send your shots out to everybody previously and unsubscribed. We've kept them on the database because you never know who you want to speak to. That's to our accountant. So you've got on a database, they've unsubscribed to your shots. You still need to contact them now and say, can we keep your details on our database?
Not necessarily. No. So remember, someone
I
can.
have a mobile phone number as well. That's personal. But be just careful because they don't want the e-shot and not relevant.
Yeah.
They've still got details.
Yeah. So that's not unusual. And remember, people might give you a consent today, they might unsubscribe from your email tomorrow, but then you might recapture their consent. So they might go from consented, not consented, back to consented. So in our CRM database, we probably have a lot of people who have opted out of lots of our marketing, but they're still on there because they're still a client. So our data retention policy will state that we're going to maintain your information on our client database for X number of years after the last transaction we have with you or the last transaction we have with your organisation. So it doesn't mean if someone opts out or says, do not contact me, that you delete the information. And in fact, it can be damaging to do that, because if someone says, do not contact me, and you just delete them from that database, well, someone else might not realise that and they might inadvertently contact them. So you need to think it through.
This is exactly what we do at Close Brothers. If a customer calls and says, I want you to delete my information because I don't want marketing anymore, we make sure we explain to them that that's not a good idea, because deleting their information means another sales guy might go out and get it again. So we explain to them that we can keep minimal amounts of information to suppress it, to show that they don't want to hear from us, to ensure that we don't market to them again.
You mentioned something called an information asset register.
Yeah.
What is it?
So it's a register where we record all our data processing activities. So we record the data that we collect, why we collect it, so our legal grounds and the purposes, how long we store our data, where we store it. We do this for two reasons. One, so that we have a good hold of our data and we understand exactly what we're doing with it. And two, because the ICO on companies like ours, we have an obligation to ensure that we keep an internal record of processing. So the ICO has lots of guidance on this and the GDPR requires it. So we do that so that we can comply with GDPR if the ICO ever comes in and says, we want to check if you have this.
The Isle of Man Commissioner has a tool called Mapping the 5 Ws, which is a very sort of simplistic starting point for an information asset register. So it's a free resource from a credible source, so it's worth putting that into Google and just having a quick read through theirs. Or they have their documentation template on the ICO website as well, which again is a bit of a stripped back version of probably the very in-depth one that Close Brothers will have. But as just starting point to get you on the journey, those sorts of templates are a good idea to have a quick look at.
I think it'd be a good idea that, like our database, we have for a long time, still dealing with them. Just have verbal, well, we just dealt with a no consent at all. Is it worth setting up a consent form to send it to them before all this comes out?
Potentially, but it's really about your lawful basis and deciding what's appropriate. So I'll use our example. So we've got a massive database, as you can imagine, of clients and prospects and business partners, and each one of those has what we call our client relationship partner, and so we've done a huge data cleanse as our starting point, where we've asked each client relationship partner to go through every record linked to them and to update it, so that we have a bit of a cleaner starting point to then look at the next step, which in some situations will be sending an email or having face-to-face meetings to go through the various consents. But that wouldn't stop us doing our day-to-day job in servicing the client's requirements, because we're not all working on the basis of consent there, absolutely not. We're working on contractual necessity or legitimate interest.
So we're okay with that?
Potentially.
Yes.
It's worth just analysing it. I really would think about what your lawful basis of processing is for each different type of processing, work out what it is, and that's part of what the documentation spreadsheets asks you to do on the ICO website. And they've got examples as well, so there's an example tab that can get you started, so it's worth just having a really quick look through. On first glance, there's multiple rows, which is a bit off-putting, I have to say, but once you start looking at the examples, it should hopefully all click into place what we've told you today.
Yeah, just to clarify something, we're a broker, we have appointed representatives we are responsible through the FCA. Mm-hmm. They hold their own information, so are they responsible for that, or are we?
So do you collect the information from clients and then pass their information on to?
No, they collect it. They collect it. Mm-hmm. They store it. If it's part of a finance agreement, then we will have it, but they will have their own. They have their own system. They have their own way of marketing. So, is it my responsibility, being compliance officer, or as FCA I am, but with the IPO, is it initially theirs, or is it both of ours?
So our brokers, the majority of them are controllers in their own right, because when they have that information, they have their own relationships with the client, and at times they market to the client as well. And because of that, they are seen as data controllers. So it's hard because I don't know exactly what the relationship is and what the contracts say with you and the other companies that you work with. But for us, our brokers are controllers for the most part.
You can be joint controllers of information to make it even more complicated. So in those types of scenarios, you might find that you are joint controllers of the same information pot because you might use it in different ways. That doesn't necessarily mean you're a processor of the other. But what's going to be really key in that type of a relationship is the contract you have with your brokers, and it should really clearly outlay responsibilities in terms of GDPR. So, for example, if you received a subject access request from one of their clients, you need to understand how you're going to deal with it. Are you going to deal with it? Are you going to pass it to them? So it's all of these, you need to sort of think about all these eventualities that could happen and try as far as possible to set them out in a contract. And from a liability perspective, you'd want to work out and be really clear around roles and responsibilities, just in case touch wood, it won't ever happen, something were to go wrong, so then you're really clear as to where responsibility lies as far as you can be. The ICO could still ignore what you've put in the contract, but it's worth making sure that you can demonstrate and document you've thought about all of this. So maybe going through the data protection impact assessment on that type of a relationship might be helpful to help you identify some areas where you maybe need to think about how you might address data issues. I think as well, things might change. So for quite a lot of my clients, I've been saying, I don't necessarily think it's the answer you're going to get to now or before May, but it's about being able to demonstrate that you've thought about it and that you've made a decision and that you're going to continually review and monitor it. And make sure that, if there's a guidance that comes out, or if someone in a similar business to you has been fined or reviewed and that makes it into the public domain, that you learn from what happens there. So for me, it's all about making sure whatever decision you come to in terms of who's controller, if they're a processor, if you're joint data controllers, just make sure there's a note somewhere about it, a minute from a management meeting or something like that. So at least you can then evidence that you thought about it. Okay, you might have got the answer wrong, who knows, but at least you've gone through that and you've made it work for what you're understanding. And the interpretation point, this is a piece of new legislation. 2 lawyers might give you a very different response on a certain question because we don't have all the guidance. But, as long as you can evidence what you've done and that you've thought about it and you've taken steps, I think you're going to be in a very strong position.
Nice, is there a follow-up to this?
Well, sort of, if you get a request in from a customer, can you just clarify for me what you would have to provide? And my understanding was any information you hold on that customer throughout your business.
Depends on what the request says. So the request can be as wide as give me all information I have, right, or it could be more tailored. But where you're in a situation where there's potentially joint controllers or where you've got processes, it would not just be necessarily your internal infrastructure. It could go into the domain of someone else as well.
This is the question. So if I had a proposal sent into me, I sent it to Close, would I advise the customer I also send your data to Close Brothers? But let's say they declined it, I sent it somewhere else, and then I say I also sent it somewhere else. You know what I mean? I just, how far do you have to go? Because you're using different controls and processes. I guess it depends on the specific request, but it's just understanding.
It is a very broad, but if they say give me all information you hold on me and tell me how you process it, it is a big exercise because it would be absolutely everything. And again, some slight complexities. It doesn't necessarily mean you need to give them the documents either. Some people put it in a chart. That it's pros and cons of different solutions, but you have to tell them what the person identifiable information is. So I had a client that said, I'm going to put everything in a chart because we've said some really nasty things about them on email. I'm just going to tell them we've got emails. You can't do that because what you have to put in the chart is the person identifiable bit, which is your opinion of them, which was very colourful. So it's easier in that situation to give them 10 ring binders of information and hope they get bored and don't find that email to be blunt. Haven't heard back from them yet as to what's happened, but there's different ways you can deal with them.
Yeah. You touched earlier on the data processors now have their own responsibilities and the legislation of international reach. So what do you do about the fact that you might use a cloud CRM system and that system could be hosted anywhere on the planet, outside the EU? How do you vet whether those, and they can be huge global organisations, the correct GDPR compliant?
Yep, so the standard contractual clauses need to be in the contract with data processors, which are very onerous for some organisations that aren't used to that and aren't aware, which is I think why the approach Close have taken is brilliant, where there's actually then an explanatory page that says this isn't Close Brothers trying to put loads of really horrible obligations on you, this is each section of the legislation. So that'll cut down obviously the negotiation, but it's part of your initial due diligence. You need to have done that due diligence on the cloud provider before you engage them. You need to have your contract, depending upon where they tell you the cloud is, there's various other things you need to deal with from an international data transfer perspective. That's why we're seeing a big move in cloud computing to European data centers. So Amazon, for example, and Amazon Web Services, they have specific European data hubs, so their EC1 and their EC2 clouds are based in the EU, but word of warning on that, there still is a very tiny sentence at the bottom that says we still reserve your right to transfer your data outside the European Economic Area. So you still need to be aware. It's easier if you've chosen the EC1 cloud because you're showing that you're trying to keep it in Europe. But again, it's about flowing it across your whole organisation as well. So whatever data you're putting in that cloud solution that potentially takes data outside the European Economic Area, you need to tell your data subjects. I read loads of website privacy policies that say we do not transfer your data outside the European Economic Area. And I'm like, yes, you do. You use Microsoft Office 365 and it's quite clear that your website is on Microsoft Azure. My data's gone. So, and it's not wrong to send your data outside the European Economic Area. There's just different hurdles you need to overcome first. So it's, from a technology perspective, there is quite a lot of due diligence that you need to go through, and some of that might need to be retrospective if you are using cloud solutions that will still be in use after May the 25th. But the likes of the more well-known cloud providers are being very customer-centric, and they've got very useful privacy centres on their websites that explains everything, and they've done everything you basically need to do, because if they hadn't, there would be a huge barrier to sale. So Microsoft, Amazon, Google, all the big players and providers have got all of the requirements in place for you. So as long as you, Rackspace, as long as you're using sort of the larger, more reputable one.
Have we got an obligation to provide our customers with a secure way for them to send their information to us, i.e. portal? Or can we just do it on email and even if it's unencrypted?
So I think you should educate as far as possible your customer base. So I used to do a lot of work for an outsourced payroll provider, and we used to get payroll information in every month. So we provided online, encrypted, secure transfer facilities, didn't stop clients emailing it through very unsecure without passwords, didn't stop them sending CDs through Royal Mail non-tracked. For me as a provider of a service, if you need that sort of, well, this was very sensitive information, you should be providing as secure a method as possible. That said, for those clients who've chosen not to use that, you can't force them to use whatever provision that you put out there. But in my view, you should be reminding them that really you don't view that, sending a CD through the post that anyone could intercept, for me with my payroll information, is totally intolerable. So, and if it got
some form of disclaimer on there to say you send it in unsecure ways.
Well, yeah, so it wouldn't, you wouldn't be held responsible if a client has sent you in a CD of information. My argument would be that's not your fault. If you had requested it in that format, that's slightly different. So you need to be thinking about data transfers and trying to make them as secure as you possibly can.
On a related theme, one of the challenges in the sort of leasing industry relates to where the lessor's obligation starts and finishes and the clients from the point of view of data. And whilst it's the client's data, therefore it's their obligation if they're returning an asset or disposing of an asset to make sure that's clean of that data. It's about providing practical measures to help the client achieve that. So a couple of things we do practically is we use Hewlett-Packard's facility up in Erskine near Glasgow, which has got government approval in terms of its procedural disposal of assets. But we've also teamed up with a business called Blanco, which allows clients to buy licenses and self-certify. So before you dispose of a technology asset, a laptop or whatever, you can actually delete the data at source and certify. So again, you've demonstrated to the regulator that you've gone through due process. You might even want to do that if a member of staff has left and you're going to transfer that device to another member of staff, just to ensure that the data that might have been kept on that device has been cleaned properly, and you can certify and demonstrate an appropriate process. So there's a number of nuances, and we've taken the view that it's better to give the client the ability to self-police.
We have to post documents back to banks, completed documents. Where do we stand on that if they go missing? Because obviously we're posting documents which will have date of birth, bank details, personal details, people's addresses.
So I think, if you're using reputable sources, if you're using Royal Mail, if you've never ever had any mail go missing, and if there's no sort of security warnings of Royal Mail having a tendency to lose them in a particular area or something like that, which they do put on their website now at times, accidents are still going to happen, you should possibly do a risk assessment as to whether certain types of them should be sent recorded delivery or some sort of courier service. It's about doing a risk assessment and making sure you're putting in proportionate and appropriate measures. If it's a tried and tested method that has never had any issue for X number of years, I'm not going to sit here and say you've got to spend X thousands of pounds a year on courier services, but you've just got to make that judgment call and document that you've had this conversation and that you've thought about it and that actually you think right now from that process, because you've never had any problem, it's okay. If you were saying to me, Royal Mail leaves my mail like 1 in every 10, letters, I'd be saying pick something else because that clearly isn't a secure service. But if you've never had any issues, it's like technology. What we're going to advise you to use today is not what we're going to advise you to be using in 5 years' time. It's all about making sure you're staying ahead and you're evaluating different options, but coming to whatever your business decision is and using that sort of privacy impact assessment that we've been through to say, you might have a risk register and you might say, there's a risk that Royal Mail could lose this information, but it's relatively low risk. And as well, for me, it's about making sure you'd be alerted to if it had gone missing. So make sure you follow up to make sure those documents have been received by whoever it is you're sending them to, because then that's your check and balance. And then obviously you'd have redress against Royal Mail or whichever postal service you use if they were to lose them. They've got a contractual obligation when you put that in the post box to deliver it. So
quite often I'll go to brokers who've been in the job for a long time, quite draconian in the way they deal with things.
Mm-hmm.
There's a lot of discussions about clean desk policy, dump the junk.
Yep.
There's brokers out there that still have big, thick files spread across the desk that are there for weeks, months, because they're being on the go for.
Mm-hmm.
Is that a breach? If there's copy driving license, passports, etc. in there, should all that be scanned?
So it's about, again, it's what's about appropriate for that individual organisation. If it's in a very secure office, then potentially it's not. But I think it is a very risky situation to have papers on desks in any offices, because you'd still have cleaners, workmen, visitors potentially coming into that arena. So it's about evaluating where it is. If it's a home worker as well, you still have obviously visitors to your home, children. If I give you my passport or a copy of my passport, I wouldn't expect it to be left on the side of somebody's desk where somebody could swipe it and walk off with it. But you need to just assess on it each company. It's different for every single company.
I've had an increasing number of customers, particularly the younger generation, in the last couple of years, wanting to send me supporting financial information on WhatsApp.
Yeah.
Is that, I know they started encrypting their messages. Is that considered a secure source?
Yeah, so WhatsApp hit the news because of terrorist use of their facility, and it's end-to-end encryption.
Yeah.
So it can't be intercepted, and WhatsApp apparently can't reverse the encryption to get the information. So yes, it is a relatively secure system. The only thing I would say is that WhatsApp is not based in the UK, it's not based in Europe, and so it is a transfer outside the European Economic Area. Yeah. So you might want to have, so we have a business policy internally about usage of WhatsApp, and we actively discourage clients from contacting us on that because we can't evidence it very easily, if I'm honest. So our preference is to use our email system or the text messages, because you can extract it in an easier format, but it's whatever's appropriate for you. But yes, it's an encrypted solution. So there is benefits of using it, and we have some clients who are based in the Bahamas and across the West Indies who that's their preferred transfer method because it's free. So that's appropriate for them, and they're aware of the risks. And at the end of the day, that is their data. So they're the data subjects. So they're the people who can complain. So if the data subjects is aware of what it is and they're dictating the tools, then you have to take that into consideration.
One thing I'd say on that as well is data minimization. So if you then take that information from WhatsApp and put it into one of your systems, delete the WhatsApp conversation.
Right.
Yeah.
I was just going to say, is there a way to make emails a robust transfer of data? Because that tends to be the way most data pass between clients and
You're probably
you can acquire and buy encryption and various other software protections either as part of the email system you use or as a bolt-on. So there are various means. In fact, and it's probably not slightly out of date, but it's we put together a white paper quite early on, actually back in July 16, about GDPR when awareness was was much less than it is now. And there's some recommendations within that paper in regard to what is in the market in relation to encryption and various other tools that you could buy in the open market to protect yourself.